Ladies and gentlemen, we will reconvene at that time. So been that great. Normally,
That makes my 6 look like a good start. Yeah, that's good for you.
the subcommittee will come to order. Good morning. Thank you all for being here today. Today we'll be taking a close look at whether VA does enough to ensure that veterans receive high-quality decisions in their claims on appeal. Veterans often wait for years for a final answer on their claims, and we owe them an answer that is fair and correct. The VA Board of Veterans Appeals is primarily responsible for ensuring that veterans receive accurate answers. And when the board decides that the Veterans Benefits Administration, VBA, makes mistakes when initially processing a claim, VBA is responsible for correcting those mistakes. We know that the board and VBA employees are dedicated to providing veterans with high-quality care decisions. Board leadership primary concern is issuing a high number of decisions on veterans' claims on appeal. Board leadership has failed to implement measures to ensure that these decisions are correct and fair for each and every veteran. Training out members is more important to the board sometimes than ensuring veterans are receiving the right answers on their claims. We question the accuracy of the over 90% quality assurance rates that the board has reported to Congress. How can the board's quality rate be that high when the Veterans Court catches the same mistakes being made over and over again? And when the Veterans Court stated that in the fiscal year of 2022, only 5% board denials on appeal were legally correct. We are concerned about whether the board and VBA inform specific employees about their past mistakes so that they can learn from them, and we will continue monitoring whether the VA is training employees enough so that they can provide every veteran with legal, accurate answers. It is important for us to ensure that our veterans receive the fair and just outcomes that they deserve. To provide insights into these quality issues, we will be hearing from VA and the U.S. Government Accountability Office. We will also hear from Disability American Veterans, the National Organization of Veterans Advocates, the law firm of Chisholm and Kilpatrick, Veterans of Foreign Wars, and the American Federation of Government Employees. I would also like to recognize Ms. Carol Whitmore, the Junior Vice Commander-in-Chief of the Veterans of Foreign Wars of the U.S., who is with us today. Ma'am, thank you so much for joining us today. I want to thank everyone again for being here today, and I'm looking forward to our conversation about what we can do to ensure the VA provides every veteran with a high-quality decision in their claims and appeals. With that, I yield to the ranking member for his opening statement.
Thank you, Mr. Chairman, for holding this important hearing on the quality of the Board of Veterans' Appeals decision-making in veterans' claims appeals. As all of my colleagues do, I've got numerous constituents with claims pending at the Board of Veterans' Appeals. The current average time that it takes to have an appeal claim adjudicated by the board ranges from less than a year to up to 2.5 years. I'm sure that the panelists here today will all agree that this is totally unacceptable. No one should have to wait that long to find out if their appeal was granted. Congress tried to address this issue in 2017 with the Appeals Modernization Act, which redesigned the Veterans Benefit Appeal System and created a new decision review process, allowing veterans to choose from one of 3 lanes to determine the path their appeal will follow. And while the AMA has shown promise, it's not working as fast as we hoped it would. And now with the implementation of PACT, there is growing concern as to whether the board will have the capacity to provide timely decisions to veterans. So today I'm hoping to gain insight into the necessary steps for improvement of the process and how Congress can help or hurt those efforts, because our shared commitment to veterans demands a proactive approach to address these challenges and fortify the effectiveness of the AMA. but we must get it right together. In addition to addressing the speed of appeals under the AMA, it's imperative we also focus on the board's quality assurance and training programs. Ensuring the accuracy and fairness of appeal decisions is as crucial as expediting the process itself. Robust quality assurance measures must be in place to guarantee that veterans receive correct decisions. Moreover, investing in comprehensive training programs for board employees is vital to enhance their expertise and ensure a thorough understanding of veterans' unique circumstances. Accordingly, I would also like to explore strategies for bolstering quality assurance mechanisms and advancing training initiatives, recognizing that the effectiveness of the AMA hinges not only on speed, but also on the precision and fairness of decisions affecting veterans. I appreciate the efforts VA has made in the past few years to streamline appeals decisions, but clearly more needs to be done. In looking ahead, I see a list of goals to improve the accuracy and timeliness of veterans' claims. I hope BVA will discuss in detail when you plan to achieve these goals, and more importantly, how you plan to achieve them. So this is extremely important to veterans that I serve in New Hampshire and their families, who expect me to not only help them navigate through this red tape, but also to cut it down when necessary. Thank you, Mr. Chairman. I yield back.
Thank you, Ranking Member Pappas. Our witnesses today, Mr. Kenneth Arnold, the Vice Chairman of the VA Board of Appeals. Mr. Arnold is joined by Ms. Mary Ann Flynn of the Office of General Counsel and Mr. Timothy Serhall of VBA's Office of Administrative Review. Additionally, Ms. Elizabeth Curda will testify on behalf of the U.S. Government Accountability Office. I ask the witnesses of our first panel to please stand and raise your right hand. Do you solemnly swear that the testimony you are about to provide is the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you. Let the record reflect that the witnesses have answered in the affirmative. Thank you all for being here today. And Mr. Arnold, you are now recognized for 5 minutes to deliver your opening statement.
Thank you, sir. Good afternoon, Chairman Luttrell, Ranking Member Pappas, and members of the subcommittee. Thank you for the opportunity to appear before you today to discuss this important topic. With me today are Timothy Serhall and Mary Flynn. I'm a VA employee, but my relationship with VA is deeper and more nuanced. As a veteran with 30 years of active duty service and as the eldest of 7 children in a family that was completely reliant on my father's 100% disabled veteran status, I view my role in VA as a sacred duty. The VA medical care my dad received kept him alive until I was 15. That gift was the driving factor in my decision to enlist at the age of 17 and pursue a life of service to this great country. After retiring from the military and serving for 8 years in the career SES, I was approved by the President nearly 5 years ago to serve in my current role at SES at the VA. It is an incredible honor and a deeply humbling experience. Our sole objective is to swiftly and fully resolve appeals to the fullest extent of the law, with fair and final decisions by a judge. Since 1933, the law has required board judges to be presidentially approved for good reason, because they must have the judgment, experience, and authority to act on behalf of the Secretary when applying the law to the facts of each individual case. This has enabled the board to say yes and grant at least some relief in roughly a third of our annual decisions, even after VA has previously said no. I'm not aware of any other federal appeal system that grants relief as much as the board does. VA has decreased wait times thanks to the passage of the Appeals Modernization Act. Last year, the board decided over 30,000 AMA appeals. Those faster decisions reflect 20% fewer remanded cases and 10% higher grant rates. VBA implemented over 10,000 full grants of benefits by the board under AMA last year, averaging less than 30 days to do it. On average, AMA appeals at the board are fully resolved, meaning there are no remands, approximately 4 years faster than it takes to fully resolve legacy system appeals. However, it takes 6 years to resolve legacy cases and almost 2 years to resolve these AMA cases, far too long for both. Frankly, the legacy system is holding us back from achieving even greater success under the AMA. Last year, the board issued 103,245 decisions. 70% of those were legacy system appeals. Nearly 60% had to be remanded, and VA still has nearly 60,000 pending legacy system appeals, over 20% of which have not been evaluated for the first time by a board judge, because other remanded appeals keep returning to the head of the line. Roughly 15% of the pending legacy appeals are being adjudicated for the 5th time or more. The root cause was identified by Congress in 2017. The legacy system allows for and incentivizes repeated revisions during the appeals process that necessitate successive remands. Some suggest that court remands mean board judges are making significant and repeated errors. That is not the whole truth. We make mistakes, but not the type of mistakes that would normally deny veterans extra benefits. The whole truth is that over 92% of the board's 100,000 decisions each year are not even appealed to the court. When court judges do rule on the merits, they overwhelmingly affirm board decisions, an average of 500 affirmances each year versus only 1 to 2 dozen reversals. Unfortunately, 78% of the appeals filed at the court each year get remanded without ever being seen by a court judge. These remands operate like legal settlements between the attorneys and most often require a board decision to be re-adjudicated with more explanation for why something could not be granted. The court's clerk annually approves 6,500 to 7,300 attorney fee requests each year, almost all for remanded cases. This generates 45 to 50 million in attorney's fees each year, with the majority going to a small number of boutique law firms, but relatively few veterans receiving any increase in their monthly compensation from a new board decision post-remand. It's time for all stakeholders to come back together for a holistic review of the veterans' disability system. That's why VA has plans with VBA to host an AMA summit with all stakeholders in early 2024. This concludes my testimony. My colleagues and I stand ready to respond to any questions you have.
Thank you, Mr. Arnold. Let the record reflect that the witnesses, the written statement of Mr. Arnold will be entered into the hearing record. Ms. Curda, you are now recognized for 5 minutes to deliver your opening statement.
Good morning, Chairman Luttrell, Ranking Member Pappas, and members of the subcommittee. I'm pleased to be here to discuss GAO's work regarding the quality assurance, or QA, process at the Board of Veterans' Appeals. As you know, if VA denies a veteran's claim for benefits or services, the veteran can appeal their case to the board. If the veteran is dissatisfied with the board's decision, they may appeal their case to the U.S. Court of Appeals for Veterans Claims. The board is filled with dedicated individuals who have worked hard to produce record numbers of decisions in recent years. The board also faces large workloads and time pressures, and these and other factors require a robust QA process to ensure that decision quality does not suffer in favor of speed or production. Moreover, since 2003, VA's management of disability compensation workloads has remained on GAO's high-risk list, due in part to large appeals backlogs and lengthy wait times. The board's QA process needs to be understood in this context and the risks that workloads pose to quality. Compounding the risk is that the board isn't dealing with an appeal once, but often multiple times, due to the practice of remanding appeals that need correction either from the board to VBA or from the court back to the board. This rework is a significant part of the board's workload. Today, I'll discuss first how the board assures and measures quality of its decisions, and second, the extent to which the board has a process for continuously improving quality. In terms of how the board assures and measures the quality of its decisions, the board has a basic process to detect errors and provide feedback to its judges. An emphasis of the board's QA process is checking a random sample of its draft decisions to detect errors. Based on this check, it calculates an accuracy rate that represents error-free decisions, meaning that the board determines that its judges have followed procedure and applied the law correctly. In fiscal year 2022, in response to one of our recommendations, the board established a goal of 92% accuracy, which it generally met last year. However, the board doesn't have written policies and procedures for calculating this accuracy rate and managing the data supporting it. Without these policies and procedures, the board can't be sure that this publicly reported measure is accurate and verifiable. Similarly, the board isn't monitoring whether its judges are incorporating the feedback they receive from the QA process. Such monitoring could inform improvements to how this QA activity is designed and implemented. In terms of the extent to which the board has a process to continuously improve quality, we found that more could be done. Specifically, certain types of errors, such as improper remands, remained among the most common from fiscal year 2020 through fiscal year 2022. Also, data show that the court remands a large majority of appealed board decisions for full or partial rework, which often is because the court found the board's explanation of its findings to be inadequate. Overall, the board lacks a process to better understand these issues, which could point to better interventions and solutions. First, board officials told GAO it has no comprehensive written plan outlining how it will accomplish the mission of its QA process. Its efforts appear to be ad hoc. Second, board officials have not fully analyzed the underlying causes of the most common decision errors or court remands. Third, the board has not systematically or comprehensively developed evidence to better understand what effect, if any, its interventions have on quality, such as consistently collecting feedback about training. Finally, the board knows little about the consistency of its judges' decisions. Studying consistency could help the board understand whether there are common misunderstandings of policy, regulation, or law. The key practices for evidence-based decision-making I highlight in my statement offer the board a roadmap for developing and implementing a process of continuous improvement. The board's planned evaluation of its approach to quality assurance could help the board develop such a process. Having observed VA over several years, many challenges facing VA stem from its leaders not fully leveraging leading management practices. Another key to addressing these challenges is fully implementing our recommendations. We've made several recommendations today. By effectively implementing them, the board would be better positioned to reduce the most common errors and associated rework, thus freeing up resources to decide more timely and accurate appeals. This concludes my prepared statement, and I'm happy to address your questions.
Thank you, ma'am. The written statement of Ms. Crater will be entered into the hearing record. We will now move to questioning. I recognize myself for 5 minutes. Mr. Serhall, good morning. Can you imagine being a veteran who has waited for years for an answer to your claim and then are told that your case has gotten sent back to the beginning because of a VBA employee didn't fulfill their statutory duty to assist? I understand a VBA employee has a duty to assist in developing a veteran's claim before the claim ever reaches the Board of Appeal. In fiscal year 2022, the board sent back roughly 6,000 cases because a VBA employee failed to properly collect all necessary evidence. We know that the National Work Queue doesn't return those cases to the claims processor who initially started the case. So my question is, how does VBA ensure that individual claims processors receive that feedback?
Thank you for the question.
Sir?
Am I on? I'm on? Okay.
You're ready.
Oh, thank you for the question.
Go after it.
VBA takes remand seriously. Of course, we want the claim moving forward and have a decision issued, not having the claims move backward in the process.
Is your microphone on, sir? I'm sorry.
Can you hear me?
There you go. Yes,
Okay.
sir.
My apologies, sir. VBA uses remand data on a more of a programmatic approach, meaning we use it to inform our training programs. What we've seen from a trend perspective is remands around exam issues. So we incorporate exam training in our initial training of new processors in our yearly curriculum.
Yes, sir, I understand that, but the issue is, and I'm talking with multiple institutes around the country, is that once a case moves forward, i.e. to the board and back down, it doesn't go back to the initial processor. So that individual is not informed that if they made a mistake, that they made a mistake, so they don't know what to correct. And then the individual that receives the case has to basically start over. And the one that suffers is the veteran.
Yes, sir. What we've found over the years is the remand cases from the board are nuanced, kind of specialized workload. So we've consolidated processing at 3 decision review operation centers with the goal of being more efficient in processing and ensuring that the veteran who's impacted gets the remand resolved as quickly as possible. If based on the volume of cases that VBA decides each year, last year we decided 1.9 million. If we were to return the cases to individual processors, a single processor may receive 1 case or less or a year.
The process itself, I understand the infrastructure, and it's one of those, this is one of the, if I could put my finger on one thing that would help improve and streamline the process, it would be to not only reorganize, restructure, or realign NWQ. Because the three institutions that you're talking about are in place. What are the numbers of success once those cases come back? Do you have that?
In the legacy space, it's about 17% get granted when they come back, but in AMA, it's more than double that last year. So between 35 and 40% get granted when they come back to VBA.
So fairly low,
Higher than
given the
legacy.
numbers.
Higher than legacy, which is a good thing.
Ms. Curta, how many times your statement that you just read, how many times have you read those same bullet points off in the past few years? I would assume that this just hasn't been created in 2023 or 22.
Well, back in 2021, I testified before the subcommittee about the board's QA process, having implemented AMA. And the topic at the time was that under AMA, the board had not established a QA process that addressed the changes to the system.
So the same talking points, basically.
Yeah.
I'll give you a little rope here, but it's basically the same talking points.
Yes.
So my question, Mr. Arnold, is, with my 34 seconds, who do these points need to fall in front of? Who is responsible for course correcting these issues? Because if she's been doing this since 2021, we're listening and we're waiting for the VA to respond. And since it's 2023, no one's doing that.
Sir, all I can say is, as the essentially chief operating officer for the board, I accept accountability for anything that we failed on here. I will, as Ms. Curta was saying, the focus was slightly different in 2021. We had not even established a quality assurance program under the new AMA system we have today.
All right, Mr. Arnold, my time's up, and I don't want to hold the rest of the members up, and I'm going to have to wire brush you on this one. You have to fix this problem.
Couldn't agree more.
And I could say this all day long from this chair, and you can receive it and walk out of here. Again, you're the one.
Yes, sir.
You have to fix this problem. No more same reports year after year after year. Because as a veteran, you understand it's the veterans that are suffering.
I understand, sir.
All right, thank you. I now recognize the ranking member Papps for 5 minutes.
Thank you, Mr. Chairman. I know VA has been highlighting recently the record number of claims that have been processed, both through VBA and the board. But volume is one metric, and with such a volume of claims, we also know that we're seeing a record number of errors as well in absolute terms. With the PACT Act, there's some concerns about claims that are being granted under the new law still being denied because VBA isn't following the guidance and SOPs related to toxic exposure risk activity. It's leading to an increase in higher level reviews, which in turn leads to more appeals at the board. So, Mr. Arnold, could I ask you this question? Has the board seen a spike in these cases? And in general, how have PACT Act claims, which should be relatively straightforward, affected the board's caseload?
Sir, we've seen some, but honestly, we haven't seen a bow wave of new PACT Act claims. I think in part because of the high grant rate at VBA. And I think another thing that's misunderstood is toxic exposure claims. The law hasn't changed. What PACT Act gave us was more conditions to presume that somebody is eligible. So if time, space, and condition are present, we can grant on a presumptive basis. So it offered more presumptives. But the basic evaluation of the case is the same under the Agent Orange Act and all of that. And that is the exposure of the veteran that led to the injury or condition. So I can say we haven't seen a bow wave yet. Doesn't mean it's not coming, but we're prepared for it.
Okay, Mr. Sirhall, maybe I can turn to you. I'm just curious, you were alluding to this a little bit before, but as we think about communication between VBA and BVA around error trends and what you're seeing, what kind of communication happens there? And if you could just give me a better sense of how that information is relayed so that folks at BVA are understanding what these trends are.
Thank you for the question, sir. So I'll break it down into two primary communication loops. One I'll call operational. The Office of Administrative Review, or where I work, has a feedback loop with the Board of Veterans Appeals Chief Counsel's Office. When a remand comes back, if the Decision Review Operations Center employee has a question or needs clarification or something just doesn't make sense to them, they will submit that to our office through central office, and we coordinate with Mr. Arnold's staff to get it clarified with the issuing judge. And that's more of an operational case-by-case initiative. And then the other initiative is more strategic. A remand tiger team that's been established. Me and my staff meet monthly with Mr. Arnold's staff to talk about more trends and strategies we can jointly implement to not only be more efficient in resolving remands, but look for ways to better understand the data to adjust our behavior to try to reduce remands in the future. And that's focused more on the AMA space. Legacy is kind of its own issue, but we want to make sure we do not repeat the legacy remand rates in AMA, and so now's a critical time.
Yeah, I appreciate that. On quality assurance, I'm concerned about these repeated remands, especially those related to reasons and bases, essentially BVA failing to properly explain itself. This speaks to a lack, I think, of internal quality control before a decision goes out the door and prioritization of quantity over quality. So if I could turn back to you, Mr. Arnold, can you explain for us what sort of review happens before a decision is being issued, and why are veterans law judges signing off on so many flawed decisions?
Thank you for that question, sir. First and foremost, the board tags a decision or tags a case for quality review before we know the result. It's randomized so that we're reviewing cases that are granted, cases that are remanded, and cases that are proposed for denial. Oftentimes, it's a mixed bag in each case. So it's a different review standard that we're doing. The class of cases going up to the court is a very select class of cases where we just couldn't get to yes. So that's one distinct difference between how we're evaluating cases at our level versus what goes to the court. It is interesting, though, that the errors we call on ourselves, which is mostly procedural, is somewhere in the 5 to 6%, and that's actually come up. It was closer to 8% a few years ago. This is the best year we've had from a quality perspective this past year, both under legacy and under AMA. The appeal rate to the court is about 8%. So they do track in terms of percentage there. The reasons and bases, I don't want to speak for my colleague from General Counsel who agrees to these remands between counsel, her GS 1314 counsel with the private bar reps usually. But I know in our private conversations, she talks about just how fact specific they are based on the judge's explanation for why they have to deny. So when it comes back for reasons and bases, it's really hard to have very clear trends on those because it's so fact specific to the cases. I hope that makes sense.
It does, and I appreciate the explanation. I'm over on my time, but I just want to underscore, I think, what Ms. Kurta was saying before about not leveraging best management practices, not fully implementing GAO recommendations. These are critical steps here. We stand ready to support you, and thank you very much for your service. I yield back.
Thank you, sir.
Thank you, Mr. Pappas. Mr. Franklin, you're recognized for 5 minutes, sir.
Thank you, Mr. Chairman. Thank you, Ranking Member, for this, for holding this hearing. The oversight that we do here is very critical to what we end up delivering for our veterans. As a veteran, I appreciate all the work that you all do to take care of them, but this is an important part of what we do. I want to pick up a little bit more on what the chairman was getting into with the lack of quality assurance initiatives. It's a recurring theme. Ms. Kurta, I actually had a hard time figuring out what was current testimony versus what had been done before, because it really seems like a lot of the same drumbeat over and over, and to me, that's just unacceptable. When I look back, and I think it's important to note some of these, and looking at the GAO testimony that we had here regarding QA processes specifically, board officials told GAO it has no comprehensive written plan outlining how it will accomplish the mission and goals of its QA process. Board officials told GAO it had not fully analyzed trends or underlying causes of the most common board-identified errors, or CAVC reprimands. The board has not systematically or comprehensively built or used evidence, not circumstantial, but evidence, to better understand and improve its interventions, such as collecting feedback about training, which comes up in some of the other testimony. The board does not assess VLJ decisions for consistency, such as whether common misunderstandings of VA policy or law exist in decisions. Ms. Kerr, do you still stand by that testimony that those are shortcomings, deficiencies you see in the QA process?
Yes.
Okay. I'm a firm believer in that what gets measured gets done, and it's important to choose what you're going to measure because any system can be gamed if you're not careful about your metrics. But it sounds like even after identifying this back in July of 2023, we're still not there. We don't even have the wrong metrics to try to take stock of. Mr. Arnold, I would understand from, I appreciate that you accept responsibility. That's noble of you, but at the end of the day, that's not good enough. I mean, you are the person in charge, and these quality assurance processes are not in place. And I think in reading through all of y'all's testimony and then what we're going to get from the next panel, that's the root of a lot of problems. You can't fix problems that you can't measure and identify that you have and then figure out how you're going to get out from under them. But I want to dive in a little bit on the decision. After the testimony 2.5 years ago almost, Congress appropriated another $228 million to hire more people because people were, lack of appropriate manning was part of the issue. So we've thrown money at that. We still don't have the QA behind it. But I want to talk a little bit in the couple of minutes we have about the decision to reduce the training requirements, the experience requirements for the veteran law judges. Whose decision was that?
Sir, one of the things I want to clarify there is we didn't reduce the requirements to become a veterans law judge. The previous chairman of the board, who retired this past year, was really thoughtful in how we hire veterans law judges. Veterans law judges have the same criteria as. Sorry, sir. Yeah,
well, let's. So that's not a requirement. Was it an unwritten rule before? Because the 7 years of experience comes up in testimony from almost everyone else we're going to hear from later. So if it was it an unwritten rule before?
Sir,
that's a pretty specific thing for a
yes,
bunch
sir.
of different
It was an unwritten rule in a couple of recruitments, yes, sir, over time that, and it actually created some challenges in the prior chairman's mind in terms of the board having insular thinking. We were not as diverse in experience at the board as we needed to be.
Is the board are you getting better decisions from the judges today than you were before that change was made?
I believe so, sir, and I believe the uptick in our quality assurance rates this year have actually demonstrated that.
But apparently you can't prove the 92%. I mean, you claim 92%, but there are no metrics that you can actually stand and show, at least according to what GAO said.
Yes, sir, we gave, I don't know how many questions and data sets we provided to GAO.
Well, but you also say that, most of the times when these are remanded, there's not any change. Well, in fact, 69% of the time there are things that change after those. So I would challenge a bit of that.
Sir, I saw that written testimony, and one of the challenges with that analysis is that was some 2020 cases, and they said if anything changed 3 years down the road. That's an entirely different case than the board evaluated.
All right, we're about out of time. I really would hope that you would stay and listen to the rest of the testimony from the others, and
yes,
where
sir.
there are discrepancies, I would hope that as the person in charge, you would pursue those. Because honestly, if we're here 2.5 years from now, it should be radically different, or you shouldn't be the one sitting there testifying. Because to me, it's unacceptable that this hasn't changed in the 2.5 years since you did this last time. And thank you, Mr. Chairman. You'll
Sir. Thank you, Mr. Franklin. Mr. DeLuzio, you're recognized for 5 minutes, sir.
Mr. Chairman, thank you, and good morning, everyone. I want to follow up on a piece of questioning from both Mr. Franklin and Mr. Pappas about the high remand rate. Mr. Franklin mentioned some of the commentary in the GAO report about there not being fulsome analysis of underlying causes, though, Mr. Arnold, you were talking with Mr. Pappas and Mr. Franklin a bit about, I think, what some of those causes are. So I'll give you a chance to clarify. Is there now, or are you undertaking a fulsome analysis, a study of what those underlying causes might be or are?
Yes, sir, we are, and I'm going to tell you, even that includes pulling individual cases. In fact, my colleague, Ms. Flynn, was talking to me about all the remands she pulled, looking for sort of consistency when we were talking the other day. I'll just give one example involving a case that I think points to the issue. We take hearings and decisions really seriously, and a judge sitting with a representative and I'll pull a 2020 case from the same analysis that was forwarded to you. We had a representative and veteran sitting before a judge saying, I'm at 50% for this condition. I would like you to find me eligible for TDIU, total disability for individual unemployability for this condition. During the hearing, I hope everybody can come and watch a hearing at some point. The judges, it's non-adversarial, the judge is trying to get to yes. And the judge is like, that dog's not gonna hunt. Didn't use those words. I can't get there based on the evidence in the medical records and what you're saying. However, what if? What if the combined total of the things that you are currently rated for, I could get to TDIU for you? Does that satisfy your appeal? 3 times yes for the veteran, yes for the representative. That case was still appealed by private lawyers twice at the court and remanded twice for further explanations. The veteran's still 100% TDIU, and nothing has changed.
So in the course of doing this analysis or study, will you be generating a report? Well, what will that product look like?
So we'll probably do something where we'll fold it into one of our required annual reports to Congress, or if it's more AMA specific, with those 180-day reports we provide to Congress every 6 months. So I would assume we would fold it into something like that.
Okay, Ms. Curta, I'll ask you, is there any, should there be specific things we are pushing the board to do in terms of what that report would look at? What would be adequate to answer some of the questions you have or the shortcomings you found?
Sure, yes. I think it would be appropriate to ask for a specific analysis of the root causes of remands from the court back to the board. But I think you should also be looking at the remands that are going from the board to VBA. And one of their largest categories of errors that they find in their case review are improper remands. So an analysis of the causes of those improper remands would be very informative as well.
Okay. Mr. Arnold, I see you taking notes. Any objection to either of those or any of those comments from Ms. Curta in terms of what you should be looking into?
Not at all, sir. And in fact, consistent with that, this is in my written testimony, the feedback system that we established is twofold: to ensure that VBA is appropriately addressing the remands issued by the judges and confirming that the board's remand return reasons under the AMA relate only to duty to assist errors that occurred prior to the initial claim. One of the challenges, the biggest error we call on ourselves for cases we pull, is what we see as unnecessary remands. And really it's a legacy mentality that we see, where remands were much more prolific under the legacy system, still are. It's one of the challenges we face. Under AMA, Congress specifically limited what we could remand for. And we see stuff still being shoehorned in that way, and it's not bad intent, it's people thinking they're veteran-centric. Because I could almost hit a recording every time we're in a hearing, and the hearing ends with, "Judge, if you can't grant this, at least remand it." That is not the right answer, especially under AMA anymore. And that's in our backyard. Okay. That's something we have to address, so thanks, sir.
Yes, sir. A little bit of time left, Mr. Sirhall. I want to ask a different question about teleworking. Have you seen negative or positive or neutral impact on productivity, recruitment, VBA and or board? And has there been any change in administration policy in the last few months or so affecting that?
Thank you for that question. As far as our field employees, the claims processors, and I'll speak about the Office of Administrative Review, who handles the remands and the higher level review process. Our retention rate is between 2.5% and 4% attrition rate, I'm sorry, so people are staying. We've also staffed up the last 2 years, so we were bringing people on. In 2022, we had a little bit over 1,100 employees, up to about 1,450 authorized last year. We achieved 85% fill rate, adding 300 more this year. So we're retaining people.
Okay.
And we're
more to say, but I see my time is out. Mr. Chairman, I'll yield back.
Thank you, Mr. DeLuzio. Mr. Self, you recognize 5 minutes, sir.
Thank you, Mr. Chairman. Ms. Curta, how many GAO recommendations in this process have not been installed?
Well, the report that we're issuing today has 4 recommendations, and we would expect to see some progress on those in the next year or so. But on this particular topic, those are the open recommendations.
So no passed or open, so only the 4.
Well, we have passed open recommendations, but not on the quality assurance process at the board.
Okay, all right, very good. You hired, in your testimony, you hired an additional 50 new veterans law judges. How many total do you have? What percentage is that?
Sir, we have 134 line veterans law judges. We also have senior executive board members, usually deputy vice chairman or myself, who sit above them, who are also holding a veterans law judge status.
Okay.
And so in the last 2 years, the plus up has been 33%, I believe, and just during the last year, that portion of that, I think, was a little over 12%.
Okay, what did you spend the $228 million that Mr. Franklin referenced? How did you spend that in this process?
So most of it was, most of our budget's personnel, sir. So almost all of our budget spend has been in hiring personnel. This last year alone, we plussed up decision-writing attorneys by 16%. We have another ad out right now. Like I said, we plussed up the judges 33%. We plussed up other staff, particularly in the hearings realm, quite a bit as well. I don't have the exact percentage on that, sir.
Yeah, the reason I ask all of this is because I also filed a bill to add 2 judges to the senior court, and simply because of the cases that they cannot hear, which this is the process that we've got to fix. So how much of this is transparency? You said you used it on personnel, but how about transparency for the veteran? Because everything that I've heard in testimony here has been internal processes, and yet we have a veteran at the end of the day. What has been spent on transparency, Mr. Arnold?
So I'm really glad you asked that. And around transparency, one, I'll point, a lot of people know it's there. In fact, our web traffic has really picked up. A year ago, the number one question for me as a veteran is, why does my appeal take so long? So we put explanations out on our website to include data that we update monthly, quarterly, and annually, so they know exactly what's going on, what the challenges are, how things are getting better. In fact, it's just been recently updated with a lot of the statistics that I provided today. But in terms of spend, we've got several things that are going on, sir. We have increased our dollars, and unfortunately, one acquisition vehicle we have has been hung up, which has been specifically related to quality assurance. The board process around quality assurance for years has been 1 or 2 permanent personnel who sit there, and then there's detailed counsel who go in there on 1 to 2 year details that are supporting that. We're looking really hard at how much of that should be permanent. So now there's a judge in charge of that office, and there's a judge in charge of the chief counsel's office that sits on top of that.
Okay, thank you for that. Ms.
sir.
Carter, would you comment on that testimony? How does that fix this problem that you just heard from Mr. Arnold?
Well, just regarding transparency, the board does have its metrics on its website, so you can see on average how much time it takes. But I can tell you that this morning I had 6 emails in my inbox from veterans who had read my statement, overnight, and they all were talking about how they just didn't know where their appeal was. They couldn't find out that individual level of information, and staff of the board, couldn't really give them answers. So I think there's an issue with individual veterans being able to see where things are with their claims.
Mr. Arnold, I will tell you, I met with VSOs, this is Monday.
Yes, sir.
Before we came back. And they showed me on your website their claims. They pulled up an actual claim, and it showed where they had added documents to it. The documents were, 1, PDFs. The documents, 1, were not hyperlinked, and 2, when they copied the address and pasted it somewhere, they could not see the updated documents. I would ask you to look into that and get back to me, because I have veterans that are very frustrated with not being able to tell not only when their cases are going to be heard, but they don't know what's been added to their records because they cannot read it.
So I'd like to follow up and know the specifics on that so I can follow up.
Absolutely. Thank you. Mr. Chairman, I yield back.
Thank you, Mr. Self. Ms. Ramirez, you're now recognized for 5 minutes.
Thank you, Chairman. So we're discussing quality in the appeals process, and obviously I think we can all agree that we have to make some significant improvements. So I want to discuss one of the ways we continue to improve the appeals process for our veterans, specifically through the training. Mr. Arnold, can you walk me through the training that board attorneys receive to help promulgate the appeals? Specifically, can you elaborate on how the board trains differently for older legacy claims, newer claims handled under the Appeals Modernization Act, as well as the new claims authorized by the PACT Act?
Yes, ma'am. I regret that I don't have the curriculum in front of me, but I can give you the basic outline of it. So when a new attorney is hired at the board, they go through a 6-month onboarding process that is all training. We've changed that up in recent years to make it more heavily weighted towards mentored writing with these differences that you're talking about. But before it was heavily just the classroom PowerPoint, and now there's more learn by doing. So it's front-loaded with about 2 months of heavy classroom and mentored writing, and then the remaining 4-month period is you have assigned mentors who are reviewing draft decisions that are going to different judges where you get feedback. And that's preparing them for after their 6-month initial onboarding process, when they are full up with the judge's team, writing for that judge, that they're just not hitting they're hitting the ground running rather than just starting to write at that point in a robust way. I don't know if that answers fully, but it is split between understanding the distinction between legacy cases and AMA cases. Procedurally, they're just handled differently.
Okay, yeah, that was
Yes.
specifically what I was interested in.
There's also, we have, I think, 2 hours of training in that around PACT Act specifically. Somebody asked about that.
yeah.
So there's a lot of topical things that are in there.
Got it. And so just a follow-up on that, is the training that you're offering with that 6-month process, is that only for new attorneys, or are senior attorneys also given updated training?
So thank you for that, ma'am. Yes, senior attorneys are given more updated training. I know in a letter to the committee, to the chairman and the ranking member, the chairman just responded to, I think, specific training around PACT Act as an example. But training, we stood up a professional development division under the Office of Chief Counsel, which also oversees the quality assurance process. Because in the past, the training was kind of bifurcated between those two because they were in separate parts of the organization. So we consolidated them under one umbrella. So that training focuses on, topically, so many things. They're offering seminars every week. There's certain portions that are mandatory. There's stuff that we say, you gotta give up an hour or two to do this.
Send me the info. I'd like to see just some
Yes,
of that
yes,
updated
ma'am.
training. I know that we're up in time. I just want to ask you one specific follow-up to that, and then I want to move on to something else. I'm interested in how the board leadership incorporates some of the observations and feedback that they're getting from the frontline employees on the training. So is there a process in incorporating that feedback into the new training or the ongoing training?
There is, ma'am. They're all surveyed by this professional development training staff, the attorneys who are running that. And I think at every single block of instruction, I think they may have a survey process that
Okay.
gives them that feedback.
Got it. Thank you. Thank you, Mr. Arnold. So I want to pivot to the findings from the GAO with the time I have left. Ms. Curta, how does the absence of, so in your testimony specifically, you mentioned that the board lacks a comprehensive written plan outlining how it's going to accomplish its mission and its goals of quality assurance. Ms. Curta, how does the absence of such a plan on the board's ability to set priorities, address common errors, and improve its QA efforts? And let me ask you a follow-up just so you can answer both, and then we'll close there. What are some key elements that you think should be included in that comprehensive plan for a QA process based on your understanding of best practices?
Sure, I can cover those both. I mean, the absence of a plan means that they have a mission, which is a valid mission, but they don't have a specific aspiration or goal for what improvements in the quality process they want to accomplish. And it's hard to do that when you don't have any data, specific data on what you need to tackle and what you need to improve. So I think a good plan would have specific goals for improvement, metrics for what they would expect to see changes in the goals, and specific actions they plan to take to achieve those goals, and milestones for when those actions will take place, and who's responsible. So those are all good elements of a plan. And oftentimes, these are things that we don't see at the VA. I mean, not just the board, but across the board at the VA, we see a lack of good planning.
Thank you. Chairman, I yield back. Thank you.
Thank you, Ms. Ramirez. Mr. Subcommittee, you're now recognized for 5 minutes, sir.
Thank you, Mr. Chair. I have a few questions here and piggyback off some of my colleagues' comments. Now I can't find my glasses. Oh, here we go. There's been progress in the number of claims and appeals being processed, but recent reports have also indicated that this has come with a drop in attention and detail and a high rate of claims wrongly thrown out or continually sent back and forth between VBA and the board. So today, I hope that we can learn on how we can best streamline VA processes and ensure our veterans and their families are taken care of. So first question, Ms. Flynn, in roughly 80% of appeals in the court in FY22, the VA Office of General Counsel agreed that the board made substantial errors in their decision-making and recommended that Veterans Court remand the cases back to the board. What do you think are some of the primary factors contributing to the high rate of necessary corrections? What are some of the most common errors your team has encountered? And also, do you think it's important for individual board employees to learn from their errors so that future veterans are not harmed in the same way?
Thank you. Yes, my office represents the Secretary before the Court of Appeals. And so we do so keeping in mind that the Secretary is the nation's advocate for veterans. With that backdrop, plus the fact that this is a uniquely proclaimant system, the end result is there are often times where we're the ones working with appellant's counsel to identify error and send it back for corrections. Regarding the typical or the most prevalent errors would be a failure in the duty to assist. Most of those center around inadequate exams, the medical exams, and then inadequate reasons or bases. And that centers on the explanation that was given for the reason for the decision. And that's a tough, it's tough to quantify, it's tough to describe, it's very fact-specific. And it may hit one judge differently than another, the same way as it does different attorneys. The joint motions for remand or the joint motions for partial remand are the product of negotiation between the parties, and oftentimes there's a lot of horse trading. So the case may have multiple issues when it started at the regional office. Some of those were granted or fell apart, fell away as they worked their way. The board may have granted some of those, still denied others. And when it gets to the Court of Appeals, any number of those can be ripe for a decision. They may seek a higher...
I'm gonna jump in here because I don't want to run out of time, but to finish up here, if you can just briefly tell me how important this is, or how are individual employees learning from their mistakes or their errors through the process to make sure it doesn't happen again?
Yes, sir. We have several touch points that we have with the board where we've been working. We provide training on a regular basis. We also are in regular meetings with other components of VA. We have quarterly VLJ training. We participated in the board's conference in April, where we participate in the AMA work group with both VBA and the board. So all of those are opportunities.
Well, thank you for highlighting that. When we look at over 80%, just roughly 80% of appeals having some kind of mistakes, I'm hoping that these training or sessions that are happening to make sure it doesn't happen again there's a measurable way to prove how productive they're actually being, because with 80% it doesn't seem that that's really working. So I encourage you to look into that. Mr. Arnold, I have two questions for you real quick. When the VA Office of Administrative Review catches unnecessary remands by the board, how does the board's quality assurance and training offices, back on the same topic here, ensure that all board employees learn from those errors that they made so they can prevent errors from happening again? So same vein of the question, but now to you.
Yes, sir, that's an excellent question, actually, because every individual error that's called is transmitted directly to the judge and copying their SES level judicial supervisor, a deputy vice chairman, and so they're getting that directly. But however, in a combined basis, they are publishing monthly for the entire board a digest of errors. And there are Word documents attached to that highlight the common trends and tips for avoiding for all employees, and that's distributed on a monthly basis.
Appreciate that. I'm out of time. Just the real quick, what I'll throw in there was the $228 million that have been mentioned by several of my colleagues already. As an appropriator myself, I'm looking at this very carefully and see that in your written testimony, and the written testimony today mentions nothing about the board leadership and what it's doing to ensure that every single veteran can accurately get answers on their claims and appeals. So if throughout the rest of the questions, sir, jump in on if there's anything that the board has done to improve the quality assurance program since July 2021. $228 million is a lot of money, And again, as an appropriator, I'm looking at this very carefully.
Thank you, sir.
Thank you. Thank you, Mr. Chair. You're back.
Thank you, Mr. Subcommittee. Mr. McGarvey, sir, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Thank you all very much for being here. Mr. Arnold, last time you were before the subcommittee, I raised some concerns about workforce issues at BVA. And I just want to continue in that vein today because you've heard a lot this morning, and as you know, our veterans deserve the best care possible. Also, that our public servants at the BVA ensure that our vets get fair and objective decisions. They're the bread and butter of the whole operation. And that's why I think it's important to emphasize that BVA needs increased appropriations, resources, and tools to tackle the caseload backlog and hire more staff. We've got to ease the burden on our processing workforce. We're seeing in real time how successful the PACT Act has been in hiring and beefing up the VA to address the increased caseload. I know it's working in my district in Louisville, Kentucky. I just want to float the idea now of the need for a similar mechanism across other sectors of the VA, specifically with the BVA. Mr. Arnold, in the last hearing, I highlighted BVA's 7% attrition rate in board attorneys. We talked about that. You stated it has decreased in recent years, which is great, but as you know, is still above average, and we've got to continue to get that down. I also asked you about the decision to implement a limited competitive GS-14 career path for new hires instead of the automatic GS-14 career path. I was concerned to read in AFGE's testimony today that board leadership has not responded to AFGE's request to reconsider this decision. Mr. Arnold, when do you think you can get them an answer by?
Sir, I don't know that I have that. I think it may have gone to one of our other executives, but I'll check on that. I imagine it's not long. If it was very recent, then I for sure haven't seen it. I know there was a prior inquiry some months ago while there was something in arbitration that complicated the response because of the arbitration. I don't know if that's what we're talking about or not. Yeah.
Whatever you can do to get that answer to them, obviously, and like I said, this is to make sure our veterans are getting that top quality care they deserve. I do want to turn to one tweak that AFGE recommended in their testimony, and I thought it was compelling. They recommend that the board create a competitive journeyman, non-supervisory GS-15 attorney position. These GS-15 positions would reward hardworking employees for their contributions and incentivize retention. As you know, this model already exists in the VA Office for General Counsel, and I think it would be a really good opportunity to address that attrition rate, which we talked about. So I just want to flag for you all, for my colleagues, something I'd like to explore as a legislative initiative. And just along those lines, Mr. Arnold, what impact do you think creating 100 to 200 competitive journeyman, non-supervisory GS-15 attorney positions would have on recruitment and retention at BVA?
So it's hard to know for sure what it would have on recruitment and retention, but I can't imagine it would have a negative impact. One of the things we look at in our workforce model, we run a very flat organization, and that's been super challenging for us. Around our GS-15 ranks, we have plussed up about 33%, at least during my tenure in the last couple of years. I think we had roughly 20 GS-15 positions that were available at the board, and now it's more like 30. Which is good. Those are the positions, quite frankly, that we deplete and move into the judge ranks internally. In fact, we completely emptied our bench recently on that. So this is something we are looking at in terms of how we organize to leverage the different grade structures that are available. But I don't have help with me behind me today backbenching because we put everybody on the line to try to serve as many veterans as we can. And so one of the things we try to run lean on is not having people who are not directly serving veterans. So we're balancing those two things.
Got it. And obviously, we want our veterans to get, again, not just the care they deserve, the care they've earned. So appreciate that. I yield back.
Thank you, Mr. McGarvey. I would like to thank the panel for coming today. Ms. Curta, thank you for all of the evidence that you pushed out in front of us. Mr. Arnold, as a military man, we don't jump out of a helicopter or an airplane. We don't even back up a pickup truck without a plan of attack. From step off to mission complete, we do not do that. And I can assure you, sir, I'll be waiting for the answers and the processes that you put together from what she put out today. Is that fair?
Fair enough, sir. In fact, I couldn't agree more with some of those recommendations. In fact, one is, duh. We should have been doing that a long time ago.
Yes, sir, I agree.
Yep.
Okay, so panel 1 is concluded. Thank you very much. Panel 2, please be seated. I'm gonna grab something.
You bet, thank you. My neighbors.
Welcome, everyone, and thank you for coming today. Our second panel of witnesses will include Mr. Shane Learman of Disabled American Veterans, Ms. Dane Boyd Rauber of the National Organization of Veterans Advocates, Mr. Michael Figlioli of Veterans of Foreign Wars, Mr. Zachary Stoltz of Chisholm and Kirkpatrick, and Mr. Douglas Massey of the American Federation of Government Employees. I ask the witnesses to please stand and raise your right hand. Do you solemnly swear that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? So help you God. Thank you very much. Let the record reflect that the witnesses have answered in the affirmative. Thank you all for being here today. And Mr. Learman, you are now recognized for 5 minutes to deliver your opening statement.
Thank you. Chairman Luttrell, Ranking Member Pappas, and members of the subcommittee. We are grateful for the opportunity to appear before you. And as you know, DAV is a congressionally chartered and VA-accredited veteran service organization that provides claims and appeals representation to veterans and their families at no cost. In fiscal year 2022, DAV represented nearly 20% of all appeals decided by the Board of Veterans' Appeals. My remarks today will highlight DAV's concerns and recommendations for the legacy and AMA appeals remands and the board's intake and docketing of appeals. Mr. Chairman, in the appeals legacy system, the board is obligated to remand cases for duty to assist errors that occur at any time while the veteran's appeal was pending. If a veteran's case is remanded, the file will go back to the agency of original jurisdiction. In each remand, the board will lay out specific remand instructions to which the AOJ must adhere to. In 2020 and 2021, the board's legacy remand rate was 40%. In 22, the remand rate rose to 42%, and per the last quarterly report for 23, the legacy remand rate was 44%. Appellants have the ability to submit new evidence throughout a legacy appeal. While we acknowledge this could be a factor for the increase in remands, there are clear issues regarding the quality of these local decisions, which we believe can be traced back to training. In 2020 and 2021, the board's AMA remand rate was 28%. In 22, the rate rose to 29%, and per the last quarterly report for 23, the AMA remand rate was 32%. One of the original intents of the AMA was to reduce the amount of remands by the board. However, the increased rate of AMA remands establishes that VBA claims personnel are committing a high volume of duty to assist errors pre-decision. The board's legacy and AMA remand decisions both increased during 22 and 23. We recommend the board to not just determine the root cause of these increased remands, which we believe are mostly development errors caused by the AOJs, but provide specific training on these issues with VBA. It is imperative that the Veterans Benefits Administration focus the training on the law, not internal manuals, which are not legally binding. Mr. Chairman, we have concerns over the intake and docketing of AMA appeals. Although the clerk of the board was created in 2020 to correctly docket appeals, DAV continues to discover AMA appeals that are deemed invalid and should not have been docketed. For example, some veterans who have received a proposed reduction from VBA are filing an appeal directly to the board. However, since this is a proposed action and not a final decision, the issue is not under the board's jurisdiction and thus is an invalid appeal. This may not be discovered for months or longer while the veteran is completely unaware. In many instances, this has negatively impacted veterans as they could not take other timely action. In 2021, the board learned that a number of veterans may have had their board appeal forms mistakenly rejected for being untimely. In January 22, the board sent out another notice that delays to the board's ability to mail correspondence may have impacted timely submissions. Mr. Chairman, given the problems with the intake and docketing of AMA appeals, we recommend that a decision by a veterans law judge on the timeliness of the notice of disagreement be added to the appeals process. We believe that most appeals can be tracked back to development errors in the claims process, which really is verified by the increased rates of legacy and AMA remand decisions. Without concentrated training to correct these issues, veterans and their families will continue to experience appeals with extremely long waiting periods just for VA to finally get it right. We urge the board to take action to improve the docketing of appeals as well, as veterans should not suffer from an inadequate intake process. This concludes my testimony, and I look forward to any questions you and the subcommittee may have.
Thank you, sir. The written statement of Mr. Learman will be entered into the hearing record. Ms. Rauber, you are now recognized for 5 minutes to deliver your opening statement.
Chairman Luttrell, Ranking Member Pappas, and members of the subcommittee, NOVA thanks you for the opportunity to testify on ensuring high-quality decision-making at the Board of Veterans' Appeals. NOVA members, who are accredited attorneys and agents, practice all across the country. Nearly all of them represent veterans, family members, survivors, and caregivers before the board. NOVA participated in the original discussions leading to the passage of the AMA, and we welcome VA's statement today that they're ready to come back and sit down on the table and talk about some of the issues with it. At a recent legislative hearing, Chairman Luttrell noted that the board carries a very heavy rucksack. We recognize the ongoing efforts of board employees to deliver accurate decisions and timely benefits. We also thank Congress for increasing the board's budget 63% since 2019. These resources, however, must translate into many more decisions in the years ahead. Unfortunately, stakeholders have minimal insight into the quality assurance program employed by the board. Today's GAO report details the problems with that program. We urge the subcommittee to continue its oversight to ensure their recommendations are implemented and the results are transparent to the public. Much of the board's focus is on court remands. The board has mischaracterized court remands, stating that remands are done to correct harmless error and court clerks create remands. A remand is either a negotiated agreement between counsel for the parties or a court order because there's a recognized error in a decision. There's also the erroneous perception that reasons and bases remands do not result in benefits for veterans. The subcommittee has been provided with statistics that indicate otherwise, and our members can attest to this fact through their experience. We take issue with the Vice Chairman's characterization today of our members' efforts. The GAO report provides recommendations on how the board can analyze court remands to improve decision quality and avoid repeating mistakes that result in remands. In fact, court remands are not the main problem in this system. Rather, a far more urgent matter is the continuing high rate of remands from the board to VBA. AMA remands, while somewhat lower, still hover around 1/3. Unfortunately, data on the board's website does not provide insight as to the causes for remands. NOVA members, however, report AMA remands are often due to the same reasons many remands occur in legacy cases: inadequate or unnecessary VA exams and development. Of course, one goal of the AMA was to reduce remands. Veterans relinquished the right to retain their docket date on remand in exchange for VA's commitment to issue faster decisions, particularly in the direct review docket. There was an assurance that there would be more up or down, grant or deny decisions. Veterans relied on this commitment when opting into the new system at VA's urging. With 1/3 of decisions being remanded in the AMA, that expectation is not being realized. We urge Congress to allow represented veterans to waive the duty to assist at the board to reduce remands. The continuing cycle of remands is not solely the board's problem. VBA also plays a role by frequently failing to obtain adequate exams when needed, failing to properly consider private medical evidence and apply the benefit of the doubt, and ordering unnecessary exams. When you reduce remands, you reduce the backlog. When you reduce the backlog, employees have a more manageable workload. When employees have a more manageable workload, they produce higher quality decisions. Higher quality decisions provide better outcomes for veterans, which is a common goal we all share. The board states that it is examining the root causes of continuing remands. We urge the subcommittee to continue its oversight on this issue. Finally, the subcommittee sought feedback on board determinations of whether a notice of disagreement has initiated an appeal. The Court of Appeals for Veterans Claims recently issued a decision in the Kearns case. The court found Mr. Kearns' appeal was moot because the board corrected its error and docketed the appeal it found untimely. However, that case revealed other veterans who received such letters were not so lucky. Counsel for Mr. Kearns estimated that somewhere between 1,500 and 2,000 other claimants received erroneous letters. The board was unable to accurately determine how many were issued because of problems with its electronic systems. Although the board published a notice without an accurate way to determine exactly how many claimants were impacted, there is no doubt there are veterans who have no idea that their appeal could be reinstated. We thank Chairman Luttrell for introducing H.R. 5891, which would require the board to include a written determination of whether the notice of disagreement was adequate and timely. It is critical that this basic jurisdictional question be answered by the decision maker and not by an administrative employee. We thank you again for the opportunity to testify today on this important topic and are happy to answer any questions.
Thank you, ma'am. The written statement of Ms. Robert will be entered into the hearing record. Mr. Figlioli, you are now recognized for 5 minutes to deliver your opening statement, sir.
Thank you. Chairman Luttrell, Ranking Member Pappas, and members of the subcommittee, on behalf of the men and women of the Veterans of Foreign Wars and its auxiliary, thank you for the opportunity to provide testimony with regard to the BVA and its practices. The passage of the Appeals Modernization Act was to streamline the appeals process. Under the legacy appeals system, appellants too often had to endure lengthy delays of months, sometimes years, to navigate a confusing and complex structure, and some are still now stuck in that outmoded system. A notice of disagreement is the first step in the appeals process for veterans seeking a review of their disability claim before the VA. While the NOD is a formal expression of disagreement with a decision, historically it has not constituted an appeal to the BVA. The legacy NOD initiated the appeals process, serving as the first official notification to VA that the veteran disagreed with their decision. The veteran would then have to complete Form 9 certifying the appeal to the BVA for docketing and review by a veterans law judge. Under the legacy appeal system, this is where the appeals often get stuck in the churn based on docket date, then awaiting assignment and review by their advocate, who would then submit an independent hearing presentation on their behalf. What became clear to VFW was that this process was archaic and generally unnecessary. VFW determined that the IHP was not based on law or regulation and likely a holdover from practices years ago. If a quality argument was of record, the appeal could proceed directly to the judge after our staff completed the quality review. VFW has eliminated its excess workload of legacy appeals. For more than a year, we have been at functional zero, which means that legacy appeals continue to churn through the remand system, reappearing at the BVA at any time. The Appeals Modernization Act was intended to allow for a review in a timelier fashion. VFW is concerned with the excess workload in the AMA inventory. By focusing mostly on legacy appeals reduction and cases advanced on the docket, the remaining appeals languish while more appeals continue to be certified to the board. Hiring more staff is an excellent step and one that we applaud. Delivering more decisions is admirable, but they must be accurate and timely and not just a number in a performance plan. The remand process from the BVA to VBA is a crucial aspect of adjudication and often the most confounding. Workflow may not keep pace with the progression of the appeal. When the BVA identifies deficiencies in the appeals process, it remands the case back to BVA for further action. This acknowledges that some cases may not have been thoroughly examined in the initial stages. It also reflects VA's commitment to ensuring a fair and comprehensive review of veterans' claims. VFW has found if the record was fully associated with all the evidence or a complete review completed prior to a decision, remands are unnecessary. VFW is aware that the remand rate for legacy appeals is over 40%. The typical legacy appeal has been remanded at least twice or more. The purpose of AMA was to eliminate remands altogether. It is the VFW's position that communication between the VVA and VBA is critical during this process. Clear directives that decision makers must comply with will help streamline further development of cases. Effective collaboration between entities is essential to ensure that the remand process serves its purpose without unnecessary complication. The VBA relies on various sources of data to include data from the VBA. How VBA uses this data is essential in understanding their commitment to continuous improvement. VFW would like to thank the VA Undersecretary for Benefits and his staff for showing a willingness to incorporate important changes in law or administrative process into their training. By using remand data and scrutinizing these patterns, VBA can pinpoint areas where its process may need refinement. This will allow VBA to address systemic issues and help guide the development of targeted training programs to improve production. The BVA has a substantial role in the adjudication of claims. Its decisions are at times subject to review by the CAVC, which provides legal guidance and precedents that may influence how cases are adjudicated. This increases accurate application of the law. If a BVA decision is overturned, it proves that there may be flaws in the initial adjudication. BVA must involve continuous evaluation of its decisions in identifying errors, then implement corrective measures that improve quality and reduce the likelihood of future reversals. While VFW is pleased with some of the reforms and changes made at the BVA over the last several years, there is work to be done. The AMA is a framework whose intent must continue to be revisited to keep pace with changes in regulation. Chairman Luttrell, Ranking Member Pappas, this concludes our testimony, and I am happy to answer any questions you may have.
Thank you, sir. The written statement from Mr. Figlioli will be entered into the hearing record. Mr. Stoltz, you are now recognized for 5 minutes to deliver your opening statement.
Chairman Luttrell, Ranking Member Pappas, and members of the subcommittee, thank you and good afternoon. I'm Zach Stoltz, a partner with Chisholm, and Kilpatrick. CCK is a law firm with dozens of VA-accredited attorneys and advocates handling VA benefits claims at all levels of the process. I have personally spent the bulk of my career practicing before the U.S. Court of Appeals for Veterans Claims and the U.S. Court of Appeals for the Federal Circuit. As part of a pro bono program with DAV, my office has handled over 15,000 appeals at the CAVC As part of a pro bono program with DAV, my office has handled over 15,000 appeals at the CAVC over the past 15 years. The Board of Veterans' Appeals was given a Herculean task with the passage of the Appeals Modernization Act. Already struggling with huge backlogs, it was expected to work down legacy cases while simultaneously adjudicating cases in the brand new AMA system. There is no question the men and women at the board work hard every day to serve our nation's veterans and their families. But Congress and taxpayers have supported the board with significant investments, and so far production has not reflected this. Since fiscal year 2020, the board's budget has surged by approximately 61%, escalating from $174 million in 2020 to $285 million in fiscal year 2023. Strikingly, the increase in budgetary allocation has not proportionally translated into enhanced productivity. In comparison, the board only decided 0.5% more appeals in 2023 than in 2020. The chairman's latest report lays some of the blame for the board's inefficiency on the Court of Appeals for Veterans Claims. In my nearly 20 years of practice, I have noticed it is not uncommon for some at the board to complain about the court's oversight, like the way district courts complain about appellate courts, and appellate courts complain about the Supreme Court. Putting aside for the moment the mistaken notion that many remands are simply for the board to explain itself better, the CAVC remanding 6,000 to 7,000 cases a year cannot explain why the board is not deciding more than an average of 95,000 cases over the past 4 years. The board simply must adjudicate more cases. It is the inescapable bottom line. There is a role for advocates to play in this process. In our written testimony, CCK proposed that the board more routinely accept waiver of Director of Compensation consideration of 4.16B claims and the duty to assist. Waiver is not to be taken lightly. The duty to assist is a vital part of VA's non-adversarial adjudicatory system. But with the growing sophistication of advocates, both in the VSO and private bar communities, there is a place for knowing waiver. As many of the witnesses here today noted, the remand rate from the board to the regional offices is very high, allowing for advocates and the veterans they represent to waive certain procedures when a record is fully developed will move cases along faster. This also makes more sense as we see the promises of the AMA come more into focus, but also some of the pitfalls. Remands are far more devastating in the AMA because veterans lose their place in line at the board when their cases are sent back to the regional offices. Everyone in this room today works to make the VA adjudicatory process better for our nation's veterans. The board is a linchpin and frankly the place where tens of thousands of veterans can receive justice. This hearing and hearings like it are vital to ensuring clear-eyed oversight of the board's results. I appreciate being here today, and I look forward to your questions.
Thanks, sir. Mr. Stoltz. Mr. Stoltz will be entered into the hearing. The written statement of Mr. Stoltz will be entered into the hearing record. Mr. Massey, you're now recognized for 5 minutes, sir, to deliver your opening statement.
Chairman Luttrell, Ranking Member Pappas, and members of the subcommittee, thank you for inviting the American Federation of Government Employees to participate in today's hearing. My name is Douglas Massey, and for the past 7 years, I've had the honor of serving as president of AFG Local 17, representing approximately 1,000 attorneys and support staff at the Board of Veterans' Appeals. It is a privilege to offer insights to this subcommittee on ways to enhance the board's appeals process for our nation's veterans. The foundation of well-informed decisions lies in the perspectives of those directly engaged in the work. This is where AFGE plays a crucial role. My testimony today aims to highlight areas where both board leadership and this subcommittee can support dedicated board attorneys, focusing on recruitment and retention, training, and workload and performance. The first issue I will address is the career path for board attorneys, which board leadership downgraded from a GS 14 to a GS 13. This undermines the VA's and this subcommittee's goal of recruitment and retention of talent. Board management has effectively limited the career path for board attorneys, widening the competitive pay gap among attorneys in the public and private sectors. We firmly believe that this committee shares our commitment to ensuring that veterans' claims receive the highest level of attention. Beyond restoring the GS-14 career path, we further propose that the board create a non-supervisory GS-15 attorney position. Establishing this possibility for attorneys would significantly contribute to the long-term recruitment and retention. It is noteworthy that non-supervisory GS-15 attorneys exist within VA's Office of General Counsel, setting a precedent. We ask the committee to take legislative action. Secondly, the board's decision to hire board judges without any veterans law experience is equally disruptive and detrimental to the board's mission. Historically, board judges were required to possess a minimum of 7 years of experience in veterans law, acknowledging the intricate nature of the work. Several years ago, the long-standing 7-year requirement was abruptly eliminated from the board judge hiring criteria. The result of this decision has been disastrous. Experienced judges are signing or finalizing 3 times as many decisions per week compared to their inexperienced counterparts. In addition to fewer decisions, attorneys complain that the inexperienced board judges struggle with approving quality decisions, requiring that attorneys train the board judges for whom they work. Similarly, many of the board's experienced board judges are now tasked with training their new inexperienced colleagues, which detracts from time they could devote to signing decisions. Board judges are already under immense pressure to review and sign at least 20 decisions a week, conduct numerous hearings, and mentor attorneys. Furthermore, the hiring of inexperienced board judges has demoralized attorneys because it has foreclosed promotion opportunities to these coveted positions. Many surveyed attorneys have indicated they plan on retiring earlier than expected. AFG requests that the committee take action and propose codifying the 7-year experience requirement for entry-level board judges into law. Third, the board's recent failure to prioritize quality through effective training has left attorneys frustrated and demoralized. AFGE, recognizing this gap, initiated its own successful training program. Despite the program's success, upper management has yet to implement a similar initiative. An alarming example of the training gap is the board's offering of only 2 hours of mandatory training on the PACT Act in the past year compared to VBA's 15 hours. This inadequacy leaves attorneys unprepared to navigate the nuances of the PACT Act, risking errors and inadequate decisions for veterans. Insufficiently trained attorneys contribute to delays, a backlog of cases, and ultimately hinder veterans' access to benefits. Lastly, while the board's output is a priority, an exclusive focus on quantity over quality harms veterans and disrupts the entire appeals process. AFGE strongly urges the board to lower the quota, allowing sufficient time for the required de novo review of claims files and the issuance of high-quality decisions. AFG members believe that making straightforward changes to board attorneys' compensation, promotion opportunities, training, and performance measures, together with setting minimum experience levels for board judges, will greatly benefit the productivity and effectiveness of the board. We look forward to working together collaboratively to make the changes we can. Thank you, and I look forward to answering your questions.
Thank you, sir. The written statement of Mr. Massey will be entered into the hearing record. We will now move to questioning. I recognize myself for 5 minutes. The remaining World War II vets into Korea, into Vietnam, into the Gulf War, and into the 2 wars we previously fought that just recently ended. All of those service members or veterans are moving into the Veterans Affairs Organization. The amount of weight that department has to shoulder now that our generation, my generation, are moving out, they're doing everything they can not to scuttle. We are asking them to do everything in the right for us. And they're trying to shoulder that. I want that to be said right now. And I want them to hear me say that. Each one of you listed off multiple issues that need to be addressed. Absolutely. Mr. Stoltz, you listed off the weight of your statement holds a lot to me. And Mr. Massey, your discussion is about us downgrading the GS levels and the caliber of attorneys that we're going to get inside the VA system, correct?
Could you please repeat the question?
Your statement revolved around the type of attorneys that the VA will be receiving because we lowered the GS levels, correct?
Correct.
All right, here's my issue. We are putting all of these issues out in the open that need to be addressed, and we are asking the VA to address them in its entirety. Here is 500 issues that you guys are absolutely failing on. That big machine cannot work like that. As hard as it tries, from the GAO's statement over the past years, that they keep hearing the exact same thing, that we're asking to accomplish these many things. I'm going to ask this question, and I want each of you to answer it. If you had to pick one issue that I could hand to Mr. Arnold and say, you've got 2 weeks to give me an answer and 6 weeks to fix it. And we take smaller bites of this grand apple that we're trying to swallow instead of sitting in these hearings over and over and over. What does that look like? Mr. Learman, if you had one thing you could say, Mr. Arnold, this is absolutely what I need to be done for our veterans that I think would move the needle in the right direction. And don't give me the legislation that we're pushing already. I need concrete facts. What is that one thing?
Training.
Training. I hear training all the time, okay? VA employees, from what I understand, only have to come into the VA brick and mortar twice a month. What does training mean?
I think training in this instant means looking at why these remand decisions or these errors are being made and sitting down and explaining it to the attorneys at the board, and additionally, explaining this to the employees at VBA.
Is that written out somewhere? Is somewhere in their organization or your organization? Is it? Because if we go into a meeting and we just talk to each other, you're going to retain about 2 minutes of the information that I'm saying. Is what we're asking for from our organizations written down somewhere so I can hand that to him and say, push this down inside your organization so we can change this? That's what we need. And if that doesn't exist, sir, let's get that done.
Roger.
Okay? Ms. Rauber.
Well, Vice Chairman Arnold said a little earlier that board attorneys and judges are too often going back to the legacy system style of doing things and continuing to remand when they should not be. That is something that was promised under the AMA, so I think you have to be looking at why you're remanding cases that should not be remanded. You cannot solve this problem if you cannot figure out why you keep remanding cases.
Mr. Figlioli.
Yeah, thank you. It goes hand in hand with training and what Diane just said. Quality review. If you're putting out a product that doesn't meet the standard, then how do you know to fix those issues? So we have to train them better. We have to agree on what that's going to look like. They have to know what the process is, understand the law, and apply it properly so we don't end up in the constant remand cycle. We don't end up with things going back and forth between the BVA and the VBA. That lawyer, that law judge, that staff attorney needs to know what quality product they need to produce for a veteran in order for that appeal to be heard, but then also for them to be successful as well.
Mr. Stoltz.
More decisions from the board. The process has to keep moving. The only way that veterans are going to be served is if the line keeps moving, and there have to be more decisions.
More decisions by the board.
It's not going to...
See me after class. Sorry. Mr. Massey.
Yeah. Veterans are not widgets, they're warriors. I think we need a different culture at the board, a learning culture, a growth culture. I think we're kind of all saying the same things. Last night, briefly, I talked to an attorney. He said he wanted to be switched to a different veterans law judge, and I asked why. He said he's a new judge, doesn't understand the law. And I said, well, what are the conflicts? He says, I would like to grant a lot of these decisions. He wants to remand them or deny them. And that's only one issue I brought up, is the inexperienced veterans law judges, but proper training, proper compensation, treating the workforce with respect. You know, any organization, any enterprise, I mean, everybody talks about employee engagement. You cannot have a service organization if you're going to treat the workforce the way that we are treated at the Board of Veterans' Appeals.
Thank you, sir. Mr. Pappas, you're recognized for 5 minutes, sir.
Thank you, Mr. Chairman. And obviously at BVA, we're grateful for the attorneys, the judges that are so essential in that system to ensure that it operates efficiently, but also, most importantly, effectively and accurately for the veterans that are, working toward achieving what they deserve. As such, issues pertaining to training, I think, are central, and several of you have mentioned that. Mr. Massey, you were talking earlier about the need for training, the way AFGE has, I guess, put together a training program in absence of something that you thought would be more effective coming from the board. Can you discuss a little bit about what that AFGE training program looks like and what recommendations you would have for a more permanent solution?
Yes. Management identified 1 year 40 attorneys who were struggling and failing, and they were supposed to provide the training and assistance under our collective bargaining agreement. And one of our stewards, Dr. Benton Commons, put together a group of 3 other union stewards, and he worked with these people every week on efficiency training, on understanding the law. Dr. Commons has continued doing this by himself. He's recruited other attorneys to help, and it's kind of an informal training program. I've urged board leadership to have a similar group where you take 5 or 6 attorneys off production, have a group where they can help anybody out. It can be anonymous. The problem is that the board is penny wise and a pound foolish. They don't want to take 3, 4, 5 attorneys off production to do this. But this is an investment. The 7% attrition rate, that's not accurate. We've hired probably 400 or 500 brand new attorneys since 2017. They're on a 2-year probationary period. They are not considered employees. They're considered applicants. Out of those 400 or 500 people, we've probably lost well over 50%. And so the attrition rate, their training has been, the attorneys doing the training are very committed, but we have a very flawed system, and I think we need management to address it.
Well, I agree that the training issues pertaining to morale and retention are just as important as some of the technical tweaks that we've been exploring this morning. Can you talk a little bit more about the quotas and performance metrics that have been an issue, and how have these changing standards affected the well-being of attorneys? In your opinion, what reasonable workload would balance productivity with maintaining high-quality decision-making for veterans?
Well, right now, we have an annual quota of 156 decisions or 491 issues. We believe it should be lower, around 125, 130. And we know that you cannot dictate a quota for the Board of Veterans' Appeals. However, Congress has, what is a requirement is that each decision be done de novo review, meaning looking at the whole record fresh and reviewing it. That's actually impossible with this quota. We have, everything's online, but we used to have paper files, and some of these came in boxes. It would be like, here's a box of medical records. You need to read this, you need to write a decision, and we need 3 of these a week. It's very demoralizing because the attorneys know that they're required to do de novo review, but you can't do that in this system. And people struggle, and it's almost as though there's not a thought from management about what the finished product is. Everything is a number. And I think it needs to be said, this management team, there's about 7 senior executives running the Board of Veterans' Appeals. They are all new, except for one. They have never written a decision. They have never signed a decision. I think they're struggling because I don't think they know what they're doing.
Thanks for those comments. Ms. Boyd-Robber, if I could turn to you. You mentioned a comment in your testimony that we heard during the first panel about the supposed way that accredited attorneys drag out the appeals process as a way to drive up fees. Is there a moral hazard in terms of the work that gets done in practice for these accredited attorneys?
Well, I'm really glad. I hope I'll get the chance to put that urban legend to rest here today, once and for all. Attorneys and accredited agents do not drag out cases. VA rules and regulations are very clear. There's standards of conduct that require them both to work diligently and promptly on their cases, and affirmatively, if you are dragging out or any case, you're prohibited from doing that. That would not only get you in trouble with VA accreditation, it would also get you in trouble with your state bar. Veterans talk to each other, VA practitioners talk to each other, and it would be a terrible business model for you to be doing that. And I would actually argue that accredited attorneys and agents, as well as VSOs with us today, are the people who are actually going to VA, advocating for those cases to be done faster, going to the court, filing writs, filing motions to advance on the docket. They are working diligently every day to get these cases resolved.
Thank you. I yield back.
Thank you, Ranking Member. Mr. Self, you're recognized for 5 minutes, sir.
Thank you, Mr. Chairman. I've heard one of you, and I apologize for stepping out, but the Red Cross is having members write letters to our overseas service members. Having received many times those, I know how important it is. So I missed some of your testimony, but I do want to ask, I did hear about judges that have no knowledge, no experience. So please give me examples of how that harms veterans. I believe that was you, Mr. Stoltz? No? Mr. Massey?
I believe it was me, yes.
Okay, Mr. Massey.
The story I just related, an attorney called me. He wanted to be moved from the current judge he works for. And I asked him why. He said, this guy is new. We're clashing. He's doing things incorrectly. He wants me to remand things or deny claims, and I think they should be granted. And it's a very difficult job. There was a 7-year requirement every time it was posted on USA Jobs until 2019, and there was a reason for that. I worked with a veterans law judge who's now retired, John Ormond. He worked for the IRS for a long time, and he said that veterans law is far more complicated than the tax code, and we know how complicated the tax code can be. Part of the job of a veterans law judge is to train and mentor attorneys, and how do you do that? I mean, I started this job in 1997, and I always knew if I had a decision I had to write, if I had a question, I'd go to the judge I was going to decide the decision and say, hey, what do you think about this, or what do you think about that? I always felt confident they would give me correct answers. And I don't know how attorneys are doing that these days, writing for inexperienced veterans law judges.
So how, give me examples of how they are harmed. Is it just the delay? How are they harmed?
I don't think they know how to adjudicate the appeals properly. We get stories of attorneys that they believe it should be done a certain way, and the inexperienced veteran, I mean, this could be an attorney with 25 years of experience that is a expert in veterans law, and there could be somebody brand new with 6 months, just had no prior experience, and the veterans law judge is going to tell this very experienced person how to adjudicate a claim. And if the attorney knows that it's incorrect, and maybe the claim should be granted, maybe it should not be remanded, that person has to do what the judge.
Well, what's the recourse? Do you have a whistleblower option? What is the recourse? Because there must be a recourse for someone whose superior is not trained well, whatever. What is the recourse?
There really isn't a recourse. I mean, we do what the judge says. I've been in that situation. I've kind of fought back a little bit, and it usually doesn't work out so well.
Anyone else know of a recourse? Any of our other panel members?
There's a solution. We could have it legislatively put in there. This was a policy, the 7-year requirement. If that could be in legislation, I think that would be very beneficial to veterans.
I see Mr. Arnold behind you. I would like to follow up on the recourse, Mr. Arnold. I think that's an important question. If this system is as broken as we've been hearing this morning, what is the recourse for subordinates in this situation? I'd also like to follow up on the fact that if the veterans law is more complex than the tax code, that's something that ought to raise everyone's eyebrow, if that is in fact true. If that is it, we've got a bigger problem than what we're discussing here this morning. With that, Mr. Chairman, I yield back.
Thank you, Mr. Self. Ms. Ramirez, you're recognized for 5 minutes.
Thank you again, Mr. Chairman. I want to get into the questions, and perhaps some of this is also follow-up from my colleagues. Mr. Massey, in your testimony, you discuss a lack of training. I think this also goes back to a little bit of what you just mentioned a moment ago. And in the panel before, I asked about training, both for new board attorneys as well as continued training for those that have already been there. So I want to ask you a little bit more about the initiatives to train employees. Can you elaborate a little bit more about the specifics that you want to see in training? Like, what are the ways that you want it to be improved? I want to get that on the record.
Are you talking about new attorneys being hired or ongoing training?
I think both.
Okay, I do have some ideas. The new attorneys, they have a 6-month program. It's the Professional Development Division. The people running that, very good, very qualified. They don't have a productivity standard during those first 6 months. They're just being trained. Now, right after that 6 months, they're given the same productivity standard as everybody else, the same quota. I don't think that's a very wise decision. I know that one of my colleagues worked for Social Security. They didn't have the same quota the first year that everybody else had. And here's another thing, this obsession with numbers and not looking at, there was one of our members, she, was a 24-week training program. She took 10 weeks off from maternity leave during that 24-week period. So, she missed a good portion of the training. Instead of giving her the 10 weeks of additional training, when the 6 months was over for her class, they said, nope, you're going on productivity. You're on production. Another person who had quit recently or a year ago, she didn't have a computer or something for a good portion, like the first month. And instead of giving her that time back, they said, sorry, you can catch up with everybody else. Nobody really looks at these people like they're people. Everybody's a widget. Veterans seem like widgets in some respects. The employees do. I do know that I've been at the board for a long time. The people there are very dedicated, very committed. And when I wrote writing decisions for me I really enjoyed it. And you get a sense of satisfaction, especially when you grant somebody 100% disability benefits. You know it's going to change their life. And I think instead of just the number, 103,000 this year and 111,000 next year, what is the product we're putting out there? I think that needs to be a focus.
Yeah, no, thank you for that, Mr. Lin. I appreciate it. I want to shift gears a bit now, and I want to talk about the AMA appeals and how they're being handled. So my questions are directed to Mr. Learman. During your oral statement, you mentioned the increase in remands for Legacy and Appeals Modernization Act appeals. What do you feel is the primary reason for the increase in both types of appeals, and what do you think can be done to correct the problem?
Thank you. I think it really comes down to is training and understanding on development errors. As was already said, when cases are being remanded back for an exam or clarification of a medical opinion or one that wasn't requested, if there's adequate training to understand and explain that remand and that reason to the VBA employee, then we have that same training as well with the judges. We're going to help eliminate the most common reason these cases are being remanded. When I've been doing this for about 25 years with DAV, and I was at our office in Nashville, Tennessee for a few years. Back when the Board of Veterans Appeals was conducting travel board hearings, several of the judges would offer training to that appeals coach when they were there conducting hearings for that week. They'd bring in that entire appeals team. They'd bring in some of the attorneys. They'd even invite us VSOs, and they'd sit down and talk about some of the common mistakes and errors that are found. I think that type of training to that level involving everybody is what's really needed to help avert these problems going forward.
Got it. I just have one last question before my time is up. In your written statement, you noted that the board conducted 11,000 fewer hearings in FY23 than they did in FY22. Do you have an idea why this happened?
Not really, to be quite honest. I mean, I don't really understand how you go from conducting 11,000 less hearings. There's 72,000 hearings pending right now, and if we continue to do less, we're not going to get to the end result that veterans are waiting for.
Thank you for that. Chairman, I yield back.
Thank you, ma'am. Mr. McGarvey, sir, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Thank you all very much for being here. I wanted to start off by highlighting a quote from your testimony, Mr. Massey. You wrote that AFGE members and board attorneys are not afraid of the hard work necessary to satisfy the mission of serving veterans. Thank you. Thank you for that. We know what an incredibly valuable resource we have, both in our veterans and in the people who are working to serve them and get them the care they need. What you see from this committee, if you sense any frustration at all, it's that we want to make sure they get the care they need. I was going to ask a little bit about the training that Ms. Ramirez discussed. And so since she kind of got a good answer from you guys on that, I want to shift a little bit more to what you were just talking about and follow up on her last questions. Mr. Massey, you mentioned a legislative fix earlier that you'd like us to look at. Now we're hearing there are 72,000 claims pending, 11,000 fewer claims adjudicated FY23 than FY22. What can we do? Mr. Massey, how can we help you guys? If you could snap your fingers and ask for something from us, what can we do to help our veterans get these claims adjudicated, get the care they need, they've earned, they deserve?
That's a tough question to answer. And the comment was made, if this is more complicated than the tax code, we got some serious problems. I mean, the whole system needs to be redesigned. But for purposes of this hearing, I think the Board of Veterans Appeals, I think it needs to focus on training. I think they need to, I mean, when they downgraded the position from the GS-14 to the 13, it didn't impact any of our members. This was new people being hired. But everybody was upset, and I was wondering why, from a union advocate standpoint, and it was kind of a message to them that they're not valued. And it doesn't seem like they're being valued. And you can't have any kind of customer service. The first thing you got to, if you treat the employees well, they're going to treat their customers well, their clients. And the board attorneys, they do a phenomenal job, but they need more time to do the job. They need a quota that's lower. And by the way, this whole tension between quality and quantity, it's been going on since I started 25 years ago. This is not new. It's a very difficult job. I do not envy the managers in charge of the Board of Veterans Appeals. It's very tough. And I think compensation, definitely. If you create 1 to 200 GS-15 positions for people that want to stay, I know a guy, he doesn't mind me using his name, Thomas Douglas left. He was one of the board's most valuable attorneys as far as quality and productivity. He left after 26 years. He didn't stay his 30 years. And I asked him why. He said, I'm never going to be a veterans law judge. And look at all these people. I'm going to go train somebody. You know, we need to take a look at how we're running the Board of Veterans Appeals. And we did a survey. I think you guys got it. 10 staffers came to the board about 2 months ago. And in June, I asked a question in a survey, what would you tell a member of the House Committee on Veterans Affairs about the Board of Veterans Appeals? Not knowing we were going to have this hearing. And I gave that to the staffers. And there's a common theme if you read that. And I encourage everybody to read it or to have your staffers read it. But it's all about productivity. They don't care about us. They don't care about the quality of what we're doing. And that was the common theme. Some positive notes with the surveys we've done. They do like their immediate supervisors, the veterans law judges. They like their senior counsel, the supervisors. Their direct supervisors, they view very favorably. But there seems to be a disconnect between upper management and what everybody's doing.
You hit on this, and I just briefly, we do have an incredible workforce, an amazing workforce, people coming in, day out, working really hard to ensure that our vets get the decisions they deserve. We want to make sure you guys have the tools and the support you all need as well. Throughout your testimony, you did highlight several ways the VA could improve recruitment and retention, including metric reforms, promotion opportunities, training, compensation that you just hit on. I just want to elevate those ideas, and I do hope that BVA leadership and this committee can take action on some of these items. Appreciate the work you all do, and I do know that there are big positives and highlights of working at the BVA, and we're here to support. Thank you.
Thank you.
Thank you, sir. Thank you all to our witnesses for testifying before us today about the important issues of ensuring that veterans receive high-quality decisions on their appeals. With that, I'll yield to the ranking member for his closing remarks.
Well, thank you very much to everyone on our second panel for your discussion here today and what you all do and represent. I did hear during the first panel that there's going to be an AMA summit coming up in early 2024, and I do hope that your organizations will somehow be involved in that, and that an invitation's coming your way. We'll see. But thank you to everyone who participated in today's event. This is obviously a very crucial conversation about the Board of Veterans Appeals, and it's evident that BVA's got some work to do to address these issues with the appeals process, including retention and hiring concerns, training deficiencies, lapses in quality assurance, and the impact of increased workloads on morale. Let us not forget that behind every claim is a veteran. Behind every claim decision is an employee tasked with writing it. As such, a singular focus on increasing productivity will only lead to greater employee burnout, attrition, and ultimately worse outcomes for the veterans that we all want to serve better. I know that with the implementation of PACT, VA is delivering more benefits to more veterans than ever before, so the board must continue to focus on workforce development and quality assurance as we find ways to decrease the appeals backlog. Further, the board should continue to aggressively hire new employees to balance out the workload. I would say also that VBA must continue to address at the same time the upstream issues with claim accuracy that lead to additional downstream work by the board. Ensuring veterans receive a decision on their appeals promptly, along with an accurate and comprehensive decision, remains a top priority. It's imperative that these individuals obtain the benefits rightly due to them, and we should all be committed to nothing less, and I know that we are. So I anticipate a continued collaboration, Mr. Chairman, with you, with our VSOs, with all those who have been a part of this hearing today, and I yield back and thank everyone for a productive session.
Thank you, Mr. Pappas. Mr. Massey, my colleague, Mr. McGarvey, asked one of the most profound questions, and your response was, that's an extremely difficult question, but those are the answers that we need. We need to know exactly the answers to those hard questions so we can take that information directly to the VA and make movement on it. You heard me say earlier, having these hearings where we're engaging back and forth, but we have no profound, this is the way forward. This is from step off to mission success is what we need to implement. We have to refine that in a way where it's just not Sunday lunch and you're emptying the refrigerator, okay? I don't have any other better way to put it. But again, thank you so much for coming today. I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks and include extraneous material without objection. So ordered. This hearing is adjourned. Mr. Stoltz, you want to, please, sir.